I like to characterize AI as a tool, as I've kind of used that word before, as sort of another weapon, if you will, that you can have in your arsenal to help advocate on behalf of your client.
The recent research from Anthropic, they had put AI agents in place where an agent is allowed to roam free within a server system and review email and cobble together information. And the agents that were allowed to their own autonomy, when threatened with being shut down, found emails amongst people in the data sets and used those to blackmail the folks who were threatening to shut them down.
At the end of the day, this is something that's happening, and the question is, how do we adapt to it to be the most effective advocates for our client, as opposed to sitting and complaining about it and watching the wave, wash us out?
Howdy, and welcome to the show. I'm very excited to be joined for this first of what is planned to be a monthly session with Shahrad Milanfar and Marshall Cole. We're going to be doing deep dives into AI, and part of the reason we're doing this and doing it in this fashion is because things are changing so fast that we felt it was important to have conversations from a proactive stance and also from a malpractice perspective, with each of us having our own look and background in terms of examining things. Marshall Cole, as listeners know, is an esteemed lawyer who's got a practice down in Southern California focusing on legal mal-defense. Shahrad Milanfar is a hitter from Walnut Creek who found the light, came over from the defense to the plaintiff's side, and is an early adopter of technology, and everyone knows me. So without further ado, let's go ahead and turn it over to talking about AI and new and current events in terms of what's going on there. I suggested folks either pay attention to the news or come forward with any sort of notes in terms of things that are going on in their life. With that, Marshall, Shahrad, is there anything burning for you at the top for that?
I think for me, I'm happy to jump in here. What's kind of burning is I'm seeing in the legal community a divide that's probably similar to when email came into existence and Westlaw came into existence, going from books to web-based legal research, which is, a group of lawyers who strongly resist using AI in replacing things that lawyers do versus probably a younger group of lawyers, perhaps, that has fully embraced it in almost every part of their practice, if not every part of their practice. And I think it's really, really interesting to see people sort of clinging on to the past and not recognizing that, technology is always going to be there. It's always going to change. It's always going to evolve. And we as lawyers have to evolve with it, or we're just going to be left behind. And so when I was reading these comments, I just thought it was very interesting that, some people would say nothing can replace, the advocacy of a lawyer and what a lawyer does and how a lawyer writes and thinks. And while much of that is true, I like to characterize AI as a tool, as I've kind of used that word before, as sort of another weapon, if you will, that you can have in your arsenal to help advocate on behalf of your client. So I just thought that was just a really dated way of looking at things when I was reading these emails going back and forth. And also, not surprisingly, some of them would say, a lawyer was using Westlaw and then the AI-based Westlaw, and then cited cases in a brief, and the court found that the cases didn't exist because it was, quote, hallucinating. Well, I think there was a number of errors within whatever was conveyed to the person writing that email, because if you do your due diligence in using AI and use a closed source platform versus an open source platform, you don't have hallucination problems. And so when I saw someone saying Westlaw created hallucinations, I thought that was really troubling, because really Westlaw shouldn't and can't create hallucinations because it's a closed source platform. They've only fed their model with, accurate data, the cases, the treatises that they already have. So it's actually extremely reliable to use. But of course, I always recommend double checking anyways. So I just think there's a lot of people talking about it who don't have the correct information, are throwing around terms that they don't really even understand. And again, just have this way of looking at it that it's dangerous and going to replace us lawyers and everything we do. And, I think shocker alert, it is going to replace a lot of things we do. But I think for the listeners here, start adapting, start using it, start learning how to use it, start learning how it's being used against you so that you can be a better lawyer because it's not going away. Email didn't go away. Westlaw didn't go away. It only got better. It only made our lives easier and more complicated at the same time. And I think AI is doing that like every day right now.
I'll kick it to Shahrad with kind of a pushback on what you just said, Marshall, which is, I've come across lawyers who have said things akin to, well, geez, I expect my associates to be writing things themselves. There's a difference between AI drafting and an associate drafting, and I want my work to be done by humans. Shahrad, what are your thoughts on that?
Let me address one thing that Marshall said. I think that the perception that people have about the closed loop systems hallucinating, I think part of it comes from this case that just came down, the Lacey versus State Farm case, where two law firms, were essentially using AI, and they had, I think, 4 out of 20 sites were hallucinated. And they mentioned that that came out of co-counsel and Westlaw's precision platform. So so there is that piece of it. There are some isolated incidents where that's happened. I don't know how accurate this is because they also use Chat GPT or Gemini in that research, but I think the sanctions in that case appear to have come from the lawyers not being as forthright the first time they were given the opportunity to fess up to their mistake. But there is something to be said about learning how to write and being able to do that. But at the same time, this dialogue that's going back and forth between some of the people who are resisting this so hard reminds me of the comic where there's, these like cavemen pushing a cart that has wheels that are square. And then somebody with a round wheel is standing there saying, "Hey, what do you think of this?" And they're like, "Oh, we're too busy." Right. And this is the same pushback that I got when I originally started trying cases using an iPad. Was we've done this for 40 years the same way. We use foam boards and butcher paper. I have a handwriting that no one can read, So to me, to use a foam board and butcher paper is just idiotic. So in that context, I think we have to look at it from a big picture of, all right, why are they resisting? Because they feel that this is how they've succeeded in the past. But at the same time, those same lawyers who used to go to the stack and look at cards in the library to find their cases are now using Westlaw. So why not have, the opportunity or give it a chance for the next step to occur? But that's, I've had this conversation with many lawyers who are older, who are so resistant, and they think that our abilities to think critically is going to go away, which is not a totally baseless argument, because there's some research out there that says that, as humans, we're going to be lazy if we're given the opportunity to be lazy.
On the lazy side, when somebody does decide, okay, well, yes, I'll start using AI to help me with some of the work that I'm doing, should somebody take the first answer that AI is giving them? If no, why not?
I think it depends really, actually. If you're using it from like a creative perspective on developing case themes and things like that, where you're just using it for creative purposes, you presumably could use the first answer. But I always would say no, in the sense that you can always do better with it. Like you can always ask it to follow up, give me more options, do more, do less, however you want it. And I'm just kind of talking about sort of the general Chat GPT model with things like that. But obviously, I think for the most part, you should not just accept it and then put it on paper if you're going to be using it. But if you are using it for cases, which isn't recommended, at least by me, you better check those cases to make sure that they actually do exist, which is pretty easy to do. Most people probably have Westlaw accounts. And so someone might find that it's really quick to research through Chat GPT and then just confirm that the case sites are accurate and the case actually says what you're going to cite it for. And then I think it becomes a little bit different. So I don't think it's as much like laziness as much as it really allows you to do more. I think it opens doors, versus I'm sure there are people that will view it as a way to, work less and be on the beach more, perhaps. But I think there's less of those people and more people who are viewing it as an opportunity to, be a better lawyer, and help their clients in new and different ways and be more efficient. And just because you're more efficient doesn't mean you're lazy.
Yeah, and I think a lot of times, and Marshall can probably speak on this point a lot better than I ever will, is lawyers get into trouble when they see their jobs as a burden as opposed to an opportunity to help people, right? And when you think discovery, oh my God, why do I have to do discovery or whatever, you're more likely to take the shortcut than if you look at it and say, look, this is just one component of a bigger picture. And how do I deal with it in an appropriate way so that the outcome at the end is something that's favorable for my client? And again, if a first year associate walks in and hands me a piece of work or they email it to me, I don't say, well, go ahead and file that. We have to take the next step. And why would we do it when it's a machine that's generating it as opposed to a human? It just is this a step that we have to take. And when people are faced with time crunches, that's when they seem to go ahead and take the shortcut that then backfires.
One of the concepts that a fellow I ride with brought to me when we were talking about AI and writing and then digesting information is what is known as the dead internet theory. The idea that content is being created by machines for the internet that is then being consumed by machines on the internet, and its application then in, say, the courtroom. 80% of briefing is built by AI, fine-tuned by a lawyer, submitted to the opposing side. The opposing side then uses briefing that is 80% done by AI. And then the judge or research attorney is taking these, putting them together, dropping them into be digested to figure out what the answer is. Where's the line where we're not actually lawyering anymore and it's all, in essence, being predetermined by tokens?
I think we're a long way from that. But not to say that it's not possible that we will get there. I think every court at some point in the next few years is going to have some type of AI doing something in the courtroom, whether that's just helping them manage their caseload. I mean, the Los Angeles Superior Court judges have hundreds and hundreds of cases at any given time. I'm sure there are plenty of ways to make them more efficient with how they manage their cases and get cases to trial quicker. Because right now it's manually managed, and that's just not the most efficient way to go about it. There's a really interesting new platform called Garfield.ai, which is, I believe it's in the United Kingdom, where they're now allowing you to basically use this to recover this platform to recover debts of under $10,000, and it will do the whole thing for you. You can it'll send a letter for you. So you upload the invoice. Then it says, okay, first thing you need to do is send a letter. Then it sends a letter. If there's no response to the letter within the amount of time provided, then it gives you the next step and goes and does the whole process for you, which allows their sort of small claim system to be that much more efficiently handled because it's basically automated at this point in time. I think it's not long before there are various courts here throughout the United States that adopt certain ways for people to get help easier and allow more people to have access to the courts through some of these platforms.
As it stands right now, having discussed this same issue with some, research attorneys, and one in particular who was a head research attorney at one of the appellate divisions, the feedback that I've gotten is that at this point, the courts, because of their budgets, don't have the money to really invest in the AI that's, dedicated to legal, for example. So right now, you don't have that issue where the court is fully reliant on that. But, the scary part is that I think they're using some of the cheaper, open models, which then has repercussions, of its own. But I think at the end of the day, this is something that's happening. And the question is, how do we adapt to it to be the most effective advocates for our client, as opposed to sitting and complaining about it and watching the wave, wash us out?
I think you raise an interesting point. If the courts don't have the resources, then the path of least resistance is dropping, the moving papers, the opposition, the reply brief into ChatGPT or Claude and seeing what the response is. And if you're a young clerk or intern at the courthouse where you're being asked to come up with a memo for the judge, that seems like a path of least resistance for technologically savvy people.
I agree. And also think about court reporting. I mean, at least down here, there's a crazy shortage of court reporters. To get an in-person court reporter to attend a deposition is almost impossible at some points in time. And so it's remote. But think about just a basic AI model that you turn on and transcribes everything the deponent says, and just like a normal deposition, and can identify when it didn't hear a particular word. You put in spelling and it becomes a certified transcript in some way. I mean, I think that's going to happen because there just aren't enough reporters. I think at one point in time, the Los Angeles Superior Court was offering like a huge incentive bonus program to go to court reporting school and become a certified reporter to be available for the courts. And I don't think it was as successful as they thought it might be. So a real easy solution to that is to have an AI model that works just like a court reporter. And so we obviously already have recording devices, so we're 98% of the way there. It's just getting it to be produced in a certified way that's reliable, that can then be prepared into a transcript and given to a court.
I think we're at least from my conversations with court reporters, we're at a very precarious inflection point. And precarious inflection point is, do you want to be an apprentice buggy whip maker, learning your skills as automobiles are being rolled out on the road? Or are you doing high level training for a job that is going to be probably the legislation sometime in the next 10 years, absent the court report lobby being strong enough to hold it back, doing exactly what you're talking about, Marshall?
And also, like, I don't know about you guys, but some of the depot companies I use now already give me an AI generated depot summary. It's free. And so right there, you don't even ask for it. They've eliminated what would generally be, at least on my end, a paralegal task, perhaps, or a first year lawyer task, which is a really important task as a lawyer to learn, right? To read a deposition and to summarize it, to pull the key things out. Well, now you have that. And I think they generally do a pretty good job of the depots I've taken. You can tell whether they pull that important information. And so no longer do I need to have someone do that work if that deposition summary is created, but it's also a missed opportunity to train a lawyer or a paralegal in how to do that. And so I think that's one area where I see just kind of going away based on those AI generated summaries.
Yeah, and I think that raises an important point, and that is, how do we maintain the building blocks of the skills that we need to know in order to be able to do the various jobs that the three of us do, when you don't have that ability, you don't have that as a training opportunity. So we just have to be creative in how do we bring up the younger lawyers in our firm to be able to do those things if they can simply dump that transcript into AI and have it spit out the summary and not have to go through it themselves and pick up the nuances of how do you ask a question and you set it up so you get a usable transcript or a soundbite at the end of the day.
And that's also where I think motivations come into play that differ between the plaintiff side and the defense side. On the plaintiff side, you guys contingency work, the time it takes to train a lawyer to do that is not necessarily time you get paid for, versus a defense side lawyer where we bill at, 0.1 at a time. And, those were ways to not only to train a lawyer, but, they're necessary things, but you also generated revenue doing it. And now obviously if I get a deposition summary from AI, I'm not billing a client for that. It's received and that's that. So, arguably the client benefits from it if it's accurate, right? If it's not, then they didn't, and it doesn't replace that. So I think there's this give and take on depending on which side of the aisle you sit on and how you get paid. And it's going to really dictate how you want to train people.
Marshall, I'm curious since you do defense work. My perception from my years of doing defense work is that the bills get cut significantly as it is, and now you have AI reviewing your bills, and now you have an AI generated work product that if you give to a first year associate to quality control, you're probably not going to get paid for that work. And to me, that creates a lot of pressure on the defense firms, and that may reduce some of the quality of how that translates into the representation of the client, especially the ones who are insured and the insurance carriers are paying for.
Yeah, no, I completely agree. And yeah, obviously our bills are heavily scrutinized by I don't know if it's probably AI now, but used to just be a computer algorithm, right? If your bills had a specific word that hit a red flag, it was automatically going to be cut to zero, and then you would have to appeal it. I know both of you guys are just like loving being on the plaintiff side right now. Uh, and so, but that's how it is. The adjuster on the file that we're working with, who knows the case, who knows why two people had to attend a mediation, doesn't even review the bills necessarily. And so they don't know that your time got cut from 5 hours to 0 hours because you arguably didn't comply with the billing guidelines, even though you did. But yeah, no, I think it's going to become a nightmare, especially when I think on that side of the industry, the claims side, I think a lot of their analysis and what they do is going to be taken over by AI models who can objectively evaluate a demand letter. I mean, there's even out there, which for you all basically takes information you give it and creates this beautiful demand letter with damages and tells you how valuable your case is, et cetera. Well, I think on the carrier side, they're going to have their own AI model that's going to take that AI generated, Miles, to your point earlier, take that AI generated demand letter and say, here's why it's wrong. Now, I think if the system's working perfectly, it should just objectively prepare a demand letter, and then the claims AI model should objectively evaluate it, and you'd think the case would settle, right? Like if it's all working perfectly, there would be a number that no one could really complain about. Now, of course, plaintiffs' lawyers are probably going to disagree or however it goes, but if it all works perfectly, you would think that everything just kind of lines up.
There's 2 points that I want to make on that. One of them is that the approach that you just talked about really erodes. When I started doing defense work, there was a relationship, right? I knew the adjusters, I knew the claims reps, I knew their bosses, and that relationship really mattered. And as time went on, it seems like it was less and less of a factor in terms of whether or not you were getting work from a particular company, right? And I think that's going to erode a lot of that the more AI gets involved. And then the second piece of it is, I think historically, carriers have had a very hard time with the loss of, human losses, right? For instance, what's emotional distress, pain, suffering, all that. And it'll be interesting to see how they program their AI to account for what jurors will do in a courtroom, because that's the biggest disconnect is, well, the jurors are never going to do that. And then all of a sudden they're looking down at a massive verdict and they're scratching their head about how did we get here? And that'll be interesting because ultimately the input in terms of programming and how that AI learns will determine how it evaluates and spits out the final outcome in its evaluation.
Yeah, and I think that's equally true on the plaintiff side because, let's say you use Even Up or whatever program to create this great demand letter, but you're a phenomenal trial lawyer, right? And a phenomenal trial lawyer creates value in a case far above whatever that demand letter is going to spit out. It just doesn't know that metric. And so I think that's where you certainly can't just be pumping these letters out without looking at them, because I think on the plaintiff side, you're probably undervaluing your case depending on the type of lawyer you are. And if it's on the claims side, you've got to really realistically account for who the plaintiff's lawyer is, right? That's a person who can really hit a home run and has tried however many cases or whatever, And so I think those are things that aren't accounted for, but probably can get overlooked if you're just being, quote, lazy, I guess, and, trying to have AI do everything for you.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. One of the areas that I'm really interested to see in terms of data sets and how they develop, time has passed. There was Colossus, evaluations of cases based on algorithmic information. As we have large language models and we start having the ability to gather more and more information, have that information analyzed in different ways, having a database that knows what cases are settling for, knows what verdicts are coming in at, can account for, rating a trial lawyer in terms of the quality on the firm. Theoretically, you almost have a limit approaching infinity of perfect information for valuation on cases. In theory, it won't happen, but I see that being rolled out to insurance companies as a data set where they start putting values on cases and sticking to it.
Well, there's actually a defense firm that's now, coming out with an AI to prevent nuclear verdicts. And, but they've since been hit with several nuclear verdicts. So I'm like, maybe your AI isn't working as well as you thought it was.
We just need to adjust the model.
Right? So there's that piece of it. It's like, all right, well, you're going to guarantee a result. And that's the differentiating factor, right? Is no one can guarantee a result for their client. But again, I always really look at verdicts in similar cases, but I discount them because, every lawyer is different. Every client is different. And if you switch out 2 jurors or 3 jurors out of that case, maybe you have a different result. The most valuable tool I think we have is the conversations we have with normal human beings who are looking at, the hearing what we're telling them and saying, you know what, that doesn't sound right. Or yeah, that's a great argument. Go ahead and make it.
As we touch on different topics and we stay topical, I did want to bring up the recent research from Anthropic, where they were looking at, and these were sandboxed testing, but meaning these were not real world evolutions, but where they had put AI agents in place. And these are different than what I think a lot of lawyers are using these days. It's not us dropping information into Claude or Westlaw or some other piece, but where an agent is allowed to roam free within a server system and review email and cobble together information. And the agents that were allowed to their own autonomy, when threatened with being shut down, found emails amongst people in the data sets and used those to blackmail the folks who were threatening to shut them down. And I thought that was an interesting thing just for us to talk about, both from a tort perspective, as people start the potential of deploying these, but also in terms of, are we ready for prime time with AI in terms of agents being deployed into our systems?
Probably not, right?
I'm sorry, Shahrad. I'm afraid you can't do that.
Well, I mean, you look at, for instance, Google has this thing like the agent will call and make you an appointment for, a haircut or whatever, right? I mean, and that seems pretty neat when they demonstrate it, right? But then you have this wild card of, all right, I'm going to use your emails to suggest to your boss that you're having an affair with one of your colleagues. I mean, that's what the Anthropic model did, right? And that to me is scary. And I think Miles and I talked about this. I always say please and thank you in my prompts. And, Sam Altman, the, head of OpenAI, said it's costing them hundreds of millions of dollars where people are doing that. So out of curiosity, I went on and I asked ChatGPT, do you care if I say please or thank you? It said, well, I don't care. I do notice. And it sets a nice tone for our conversations. And I'm thinking, that's a veiled threat if I ever heard one. So all things equal, Sam, you're going to lose $100 million a year because I'm going to keep saying please and thank you.
I remember you bringing that up in a previous conversation. And it certainly is an interesting piece to think about. The reason I bring up the tort side of this is with every technology that threatens our future as lawyers in, say, the personal injury world, it appears that there may be new areas where there may be opportunities, and that is, coding errors, malfeasance on behalf of agents and the deployment of them. I see areas where people certainly have the opportunity for practice as far as that's concerned.
What about, I believe there was a deceased victim, I think it was in a criminal case, who gave a victim an impact statement. It was an AI generated victim impact statement from the deceased. And so, I think there's, on the plaintiff side, a lot of opportunity for real life reconstruction. Like you all hire accident reconstructionists, and the technology is pretty unbelievable how they can do things and just make it like a multi-million dollar motion picture. Now just imagine adding AI tools to that and creating, the actual people who were injured and put them back in the car, not just like like a robot or whatever it is, like the literal person. Think about how effective that will be at, capturing the jury's attention and making it even more emotional because they can see the faces and the horror that that person went through with respect to whatever it is. So someone's going to try to get it in, into their closing argument or into their cross with their expert, and it's going to get denied. It's going to get denied. And then some judge is going to allow it. And then the door will become open to this type of thing because it's going to be the new normal. There's no longer going to be a need for just a faceless person in your video. You're going to have the actual person. And I think that's going to be very, very powerful.
Yeah, and that's a great point, because now we're seeing AI where, I don't know if you've seen these ads where you give it a picture and then it animates that picture and it looks exactly like the people who are in the picture. So that's not out of, it's not out of the reality that you're talking about. And at the end of the day, you look at the Google system that just came online for like $140 a month. I think you can basically create AI movies. That's an incredible thing. And from an evidentiary standpoint, if I can get an expert to say, yeah, this is accurate in terms of what happened, it's at the very least a demonstrative that the jury gets to see.
I agree. And so I think those are, and maybe someone's even tried already. We don't know. It hasn't been reported, but I do know there was an article where the victim, he, gave his statement. And imagine how powerful that is for a judge sitting there when you're about to sentence someone who committed a crime, and now you're looking at the person who died giving a statement. It's pretty compelling stuff.
As we get into short strokes for this episode, I did want to circle back to the idea of losing what I would refer to as the wax on, wax off exercises for clerks and associates. The idea of how doing lots of deposition summaries helps one understand how to take a good deposition. Do you, Shahrad, do you, Marshall, have any thoughts on how you're going to work with your young folks to continue their skills and stay current? Meaning, we don't teach people how to use a typewriter anymore because it's really not necessary. Yet people still know how to type. Is there a similar analogy or a similar way that you've been approaching the training of younger people, taking into account these new AI tools that are coming out?
From my view, it's still new enough. And again, this is where plaintiff versus defense differs. The incentive isn't quite there for me to adopt AI across the board. I think law firms are certainly in interviews with new associates. It's been asked to me is, how are you using AI? How have you adopted into your practice? And 9 out of 10 times it happens, they bring up a platform that I've never heard of because there are just so many, and it's like, oh, I haven't heard of that. I go and look at it and it's interesting or it's not, but they're asking about it. So they're already aware that it's going to be a part of their practice. So for me, it's just still, I allow it to be used for creative purposes, developing case themes, deposition questions on an expert that you aren't really familiar with, things like that. So I haven't allowed it to replace the true legal work that gets done here. even discovery responses. There's plenty of platforms that streamline that. But for our purposes, we're not there yet. But if I did get there, I would only allow people to use that who were experienced lawyers, because then they know what the right discovery response should be. Sure, it got created in 10 seconds, but a first year lawyer doesn't know if what was created is actually what should be there, right? You got to know how to check. If you're going to check boxes to insert objections, you need to know which objections to check the boxes. So only an experienced lawyer is going to know those things. And then your safeguards are already working for you, where a younger lawyer can certainly learn how to use it, but they really need to understand objections or whatever it is, the content, what you put in a response, what you don't, how it's worded, how much information you want to put in. Maybe you want to be a little more cagey. There's all kinds of strategy, as we know, that goes into how a defense lawyer responds to discovery. Basically just give them nothing, and propound 490 special interrogatories. So that's kind of how I do it.
Thank you, Marshall. What about you, Shahrad?
I mean, I think what's important to keep in mind is training people to understand the why. And that helps them know the how, right? And so why are we arguing about this piece of evidence? Why is it important? How do we tell the story? Why are we telling the story in this sequence? And there's a lot of things you can do even outside of our offices, right? They can go to trial training programs. They can go to storytelling classes, improv classes, acting classes. I've read an evidence book 3.5 times, and I'm going through it I'm about to finish it. I'm halfway through it, right? Why? Because I don't need to know the exact code section, but if I can understand the basics of why that code section is there, then I can argue out of any evidentiary issue that I need to do. And I think, like we've talked about before, Miles, is that people need to take an active role in their own development as well, right? So we want to encourage our associates to be interested in their own development, learn skills, ask questions. And if you're going to come to me with a question, I'd like you to be able to give me your solution first, and then we'll work through it and see if that's what we should do.
For me, I think it's a nice jumping off point to start, what's going to be an ongoing and collaborative discussion as topics come up, because they just literally come up every day. I mean, every day I get an email about a new CLE for AI something. So it's couldn't be more relevant.
Well, I'm looking forward to having this journey with the two of you. So
Likewise.
Thanks for having us.
Yeah.
And likewise with all of you listeners out there. If you have any questions, comments, feedback, your own thoughts on AI and its implications, please reach out at podcast@coopers.law so we can address it. Like what we're doing? Leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.